Welcome to literary and jury charge practice. Ready? We'll start out with some jury charge. Here we go. Ladies and gentlemen, you have heard the evidence presented in this case. It is now my duty to charge you on the law that you are to apply to the facts that you find from that evidence. You as the jury and I as the judge have separate functions. It is your function to find what the facts are in this case. With respect to the facts, you and you alone are charged with that responsibility. My function is to charge you on the law to be applied to the facts that you find in order to decide this case. With respect to the law, what I say to you is binding on you, and you must follow all of my instructions. The parties are entitled to have this case decided pursuant to established legal standards that are the same for everyone. Those are the standards that I will give to you and that you must follow. If what counsel has said about the law differs from what I tell you, you must ignore counsel's interpretation of the law. You must decide this case based only on the law that I give to you. I do not believe that there will be any inconsistency between the law contained in this charge and anything else I may have told you about the law at an earlier stage of the proceeding, but if there is, it is the law contained in this charge that is to control. I do not have any preference as to the outcome of this case. My task is to apply the rules of evidence and to charge you on the law. It is for you alone to decide the case. You are the sole judges of the facts. It is your duty to find the facts. You are to recollect and weigh the evidence and form your own conclusions as to what the facts are. You may not go outside the evidence presented in court to find the facts. You may not resort to guesswork, conjecture, suspicion, or speculation, and you must not be influenced by any personal likes or dislikes, prejudices, or sympathy. You must carefully consider all of the evidence presented and the claims of each party. The state relies on you to render a verdict of guilty if the facts and the law require such a verdict. The defendant relies on you to render a verdict of not guilty if the facts and the law require that verdict. Both parties rightly expect that you will consider all of the evidence and treat their claims fairly and justly. The evidence from which you are to decide what the facts are consists of the stipulation of the parties, the sworn testimony of witnesses, and the exhibits that have been received into evidence as full exhibits. The testimonial evidence includes both what was said on direct examination and what was said on cross-examination without regard to which party called the witness. In reaching your verdict, you should consider all of the testimony and full exhibits. There are a number of things that may have been seen or heard during the trial that are not evidence and that you may not consider in deciding what the facts are. Those include 1. Arguments and statements by the lawyers. The lawyers are not witnesses. Their arguments are intended to help you interpret the evidence, but they are not evidence. If the facts as you remember them differ in any way from the lawyer's statements, it is your memory that controls. 2. The questions asked by the lawyers are not evidence. It is the answer, not the question or the assumption made in the question, that is the evidence. 3. Testimony that has been excluded or stricken is not evidence. 4. Testimony or exhibits that I have told you are to be used only for a limited purpose are not evidence for any other purpose. Any other use of that evidence would be improper. 5. The document called the information that you will have with you in the jury room is not evidence. The information is merely the formal method of accusing a person of a crime in order to bring him to trial. You must not consider the information as any evidence of the guilt of the defendant or draw any inference of guilt because the defendant has been charged with a crime. 6. Anything you may have heard about the case prior to the commencement of trial or outside of court is not evidence, and you should disregard it. 7. Pins worn by spectators are not evidence, and you should not let them affect your deliberations. You may consider both direct and circumstantial evidence. Direct evidence is testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is evidence involving influences reasonably and logically drawn from proven facts. Let me give you an example of what I mean by direct and circumstantial evidence. If you wake up in the morning and see water on the sidewalk, that is direct evidence that there is water on the sidewalk. It is also circumstantial evidence that it rained during the night. Of course, other evidence, such as a turned-on garden hose, may explain the water on the sidewalk. Therefore, before you find that a fact has been proven by circumstantial evidence, you must consider all of the evidence in light of reason, experience, and common sense. In deciding this case, you may consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any evidence. Right, let's try some literary practice now. Let's see what we have. This is called Know Your C's and D's, a guide to a few terms you'll see on your auto policy. Ready? Here we go. Like many official documents, an auto insurance policy can be intimidating. At first glance, it may look like alphabet soup filled with unfamiliar terms, and the prose isn't as scintillating as the People magazine on your coffee table. But before you stuff your policy into a file folder unread, consider this. If you were involved in a collision, do you know if your insurance would cover repairs? What if a tree fell on your car during a windstorm? Or what if your car was vandalized? Reading your policy and knowing your coverage before a loss is too important a task to avoid. This glossary can give you a better handle on your C's and D's, referred to in your policy as collision and comprehensive coverage and deductibles. Understanding these terms can help you communicate with your insurance agent about your options so you can choose the best coverage for your needs. Moreover, it will give you peace of mind on the road. Collision coverage typically pays to repair damage your vehicle sustains in an accidental collision with another car or an object, such as a telephone pole or a tree. The coverage is no fault, which means who caused the crash doesn't matter. It is generally the most expensive type of coverage, but with a higher deductible, say $1,000, you can reduce your premiums considerably. Comprehensive coverage typically covers auto losses that result from anything other than a collision with another car or object, for example, theft, vandalism, fire, earthquake, windstorm, and other natural disasters. In general, it costs less than collision coverage. A deductible is your share of your vehicle's repair bills if you file a claim with your insurer after a crash or other incident. If your deductible is $500 and repairs cost $2,000, you'll pay $500 and your insurance company will pay $1,500. The amount varies from carrier to carrier, but these days a typical deductible is between $500 and $1,000. If you have both comprehensive and collision coverage, you'll carry a separate deductible for each coverage. Although policies differ when it comes to deductible waivers, the no liability waiver is an industry standard, also known as the not at fault waiver. It means that if your car needs repairs after a crash, that's not your fault. Your insurance company will waive your deductible as long as the other driver can be identified and has liability insurance. In California, 14.7% of drivers are uninsured, above the national average of 12.6%, according to the Insurance Research Council. Depending on your state of residence, you may be able to add an uninsured collision deductible waiver to your policy. While not free, it means you don't have to pay your deductible if you're involved in a collision caused by an uninsured driver. When you make your claim, your insurer typically will need the at-fault driver's name and license plate number to confirm the other vehicle is uninsured and to apply the coverage. If you opt not to purchase collision coverage, you may be able to purchase uninsured collision coverage. If you have this coverage and you're in a crash where an uninsured driver is at fault, your insurance company will cover repairs up to a certain dollar cap, oftentimes up to $3,500. As with the uninsured deductible waiver, the insurer will likely need to verify the vehicle is uninsured before providing coverage. Let's try some more jury charge practice. Ready? Here we go. In evaluating the evidence and the issues presented, you should use your common sense, knowledge, and experience. Some of you, however, may have developed a special expertise in a certain area well beyond what an average person would have. If you have such a special expertise and it relates to some material issue in the case, you may not rely on that special expertise to inject into your deliberations either a fact that is not in evidence or an inference that could not be drawn from the evidence by a person without that special expertise. You must decide this case based only on the evidence presented in court. The notes you have taken are simply aids to your individual memory. When you deliberate, you should rely on your independent recollection of the evidence you have seen and heard during the trial. You should not give precedence to your own notes or to any other juror's notes over your independent recollection of the evidence because, as we all know, notes are not necessarily accurate or complete. Jurors who have not taken notes should rely on their own recollection of the evidence and should not be influenced in any way by the fact that other jurors have taken notes. Your deliberations should be determined not by what is or is not in your notes, but by your independent recollection of the evidence. If you have a question about any particular testimony, you may ask that it be read back to you from the official record, so there is no need to rely upon notes. The credibility of witnesses and the weight to be given to their testimony are matters for you to determine. However, there are some principles you should keep in mind. You may believe all, none, or any part of any witness's testimony. In making that determination, you may wish to consider the following factors. 1. Was the witness able to see, hear, or know the things about which that witness testified? 2. How well was the witness able to recall and describe those things? 3. What was the witness's manner while testifying? 4. Did the witness have an interest in the outcome of the case or any bias or prejudice concerning any party or any matter involved in the case? 5. How reasonable was the witness's testimony considered in light of all of the evidence in the case? 6. Was the witness's testimony contradicted by what the witness has said or done at any other time, or by the testimony of other witnesses, or by other evidence? If you find that a witness has deliberately testified falsely in some respect, you should carefully consider whether you should rely on any of that witness's testimony. In deciding whether or not to believe a witness, keep in mind that people sometimes forget things. You should consider whether a contradiction is an innocent lapse of memory or an intentional falsehood. That may depend on whether it has to do with an important fact or only a small detail. The weight of evidence does not depend on the number of witnesses testifying on one side or the other. It is the quality and not the quantity of evidence that controls. All of these are factors that you may consider in finding the facts. An expert witness is a witness who has specialized training or experience in a particular field. Most witnesses can testify only to facts that they have personally seen or heard and are not allowed to state opinions. Because of their specialized training or experience, expert witnesses are allowed not only to testify concerning facts, but to state opinions on issues within their field of expertise. A witness's specialized training or experience does not put that witness on a higher level than any other witness, and you are to treat expert witnesses just as you would treat any other witness. It is entirely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness stated. It is also entirely up to you to decide whether you accept the facts relied upon by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to accept or reject the testimony or opinion of an expert witness in whole or in part. You should consider whether the witness's opinion was based on sufficient education and experience, and whether the witness's testimony was motivated by any other bias or interest in the case. You must also keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find them to be, you may reject that opinion in whole or in part. You must also remember that expert witnesses do not decide cases. Juries decide cases. An expert witness is like any other witness in the sense that you alone make the judgment about how much credibility and weight you give to the expert's testimony and what conclusions you draw from that testimony. Let's try some more literary practice next. This is called Jewels in Flight. Jewels in Flight. Here we go. No wonder they're considered nature's jewelry. These airborne insects are emblazoned with metallic sapphire, blazing amber, or sunfire jasper, all artfully arranged atop delicate wings in patterns that soothe the eye and make you yearn to get within touching distance. Their names are fierce in comparison to their beauty: tiger swallowtail, monarch, morning cloak, but butterflies are more than living ornaments that decorate our nature trails. Their pollinators, reminds Forrest Urban, manager of live invertebrates at the National History Museum of Los Angeles. Every part of their life cycle is part of the food chain, and those gorgeous wings, they are essentially dead material, she says, designed to trick birds and other predators so that the butterflies can take a beak strike but continue their life's work to keep those flowers blooming. Last year, the Natural History Museum redesigned and rebuilt its popular butterfly pavilion, adding more vertical space for flight and more places for the butterflies to perch. The habitat offers a look at each and every life stage, allowing visitors to see how these creatures transform from tiny eggs to nature's jewels. Museum tickets that include admission to the Butterfly Pavilion are $10 to $17. 900 Exposition Boulevard, LA 213-763-3466. One more literary article here. This is called Where Scrubbers Grow. Ready? Here we go. Best known for its farmlands and wineries, the rolling hills of Central California hold another unexpected offering, one of the few loofah or loofah farms in the U.S. that produces thousands of the fluffy scrubbers each year. Deanne Kuhn started the loofah farm 18 years ago as a hobby. It's a plant with an attitude, she says, about the somewhat temperamental loofah vines, which produce the elongated gourds. The vines can grow a ½ inch to an inch per day during the summer months. Typical mass-marketed imported loofahs are chemically treated and tend to be hard as a rock before and after getting wet, Kuhn says. Cultivated from heirloom seeds, these super soft loofahs from Kuhn's farm are organic and long-lasting and can be used for bath, kitchen, car washing, and more. Toss them into the dishwasher to clean and reuse. Allow them to air dry. The Kuhns offer free drop-in tours, and visitors often bring picnic lunches to enjoy among the charming garden tchotchkes, bottle trees, and eccentric statuary, where numerous birds, bees, and monarch butterflies flit, and the herbs and the 1,000 loofah plants that occupy the farm's 3 large greenhouses. The gift store sells handmade soups, lotions, bath-related items, and of course loofahs. Tours are available 10 a.m. to 4 p.m. Wednesday through Sunday. 1457 Willow Road, Nipomo, 805-343-0883. All right, and that will conclude our literary and jury charge practice.